Alright, welcome back to common legal terms. These are terms that begin with the letter B. We're going to start off with the term bail, which is commonly referred to as a recognizance of bail. Especially when somebody's involved with a criminal matter, bail can represent an actual sum of money, or it can represent a term that means that somebody is released from police custody before their trial is heard. I'm going to produce a whole separate video on bail itself, the reasons that somebody can be detained and what the Crown has to prove as far as keeping somebody in custody before their trial is heard. Balance of probabilities I'll discuss a little bit later in this video. When somebody is going through a bankruptcy proceeding, that means that they're trying to get protection from debtors, from people that you owe money to. The bar is a term that's used to describe the legal profession as a whole, and it's also used to separate the judge's bench and the front row of lawyer seats from the public area. It's also a term that's used to describe the case at hand. So when somebody says the case at bar, that means the case before the judge's bench. A barrister is just another name for a lawyer. The bench is basically the judge's seat in the courtroom. Either judge or judges. That can be multiple judges. A bench warrant I will talk about in another video. The best interest section of the child is a term that's commonly used in the Children's Law Reform Act in Ontario. The test is set out for what the court shall consider in assessing what is best for the child as far as an application for custody or access. So if you're applying for custody of a child, this test will be applied. I'm going to include a link below to the Children's Law Reform Act so you can take a look for yourself. Beyond a reasonable doubt, I'll discuss a little bit later. A bill is proposed legislation that a government is wanting to enact. When something is binding, that means it's mandatory. Now, in a court decision, when a judge makes a court order, that means that maybe a higher court has said that something needs to happen in this type of similar case. Or it could be that a law tells the judge that he has to have he has to have an order of some sort. A bond is just a promise to the court, and that could include a surety or a person that's making a promise to the court to pay a certain amount of money to make sure that somebody who's out on bail will keep their promise to the court. A peace bond is another promise to the court, making sure that somebody abides by some kind of behavior, for instance, to keep away from somebody. This is similar to a restraining order. A breach is a breaking or an infraction of law or an obligation, such as a bond or a bail condition. A brief or a legal brief is simply, or I should say, it can be a document that needs to be completed at a certain step in a case. So it could be a summary of one side's position. The burden of proof is the proof needed in a case for the judge to make a decision on. So, for instance, you've heard the term beyond a reasonable doubt. This is what's called a burden of proof. So the Crown has to prove beyond a reasonable doubt to the judge that the accused person in a criminal matter has done what they said has been done. So, for instance, comparing this to balance of probabilities, for instance, a reasonable doubt burden of proof is much higher than a balance of probabilities. For instance, reasonable doubt could be considered to be 80 to 90% sure. So the judge is 80 to 90% sure that the accused has done something or that a certain law applies to the accused. The balance of probabilities, for instance, is a different level, a much lower standard, and it's typically at least 51%. So it's more probable than not that something has occurred or that a law applies to one party or the other. There are other burdens of proof. For instance, reasonable and probable grounds. This is a very low standard of proof that, for instance, the police have to have in order to lay a charge against somebody. So if there's reasonable and probable grounds, or RPG, as police may use it, then this standard of proof is approximately 20% sure. The police are 20% sure that something has occurred that falls within a criminal offense. So that's a very low standard of proof that's needed. And this is the reason why some cases are go to a charge phase and then the Crown withdraws the case because there isn't a reasonable doubt standard of proof that's met. Thank you for watching. Let me know what you think about the new format, if it's okay to follow, and I will be sure to post a new video very soon.